Have you ever downloaded music from the internet? When you did, were you sharing a treasured experience and passing along a gift? Or were you shoplifting and passing along stolen goods? Those are very different descriptions of the same activity, aren't they? Joel Tenenbaum was 16 in 2003 when he received a letter demanding $5,250 for 7 songs he had downloaded from the internet. Joel was scared, so with help from his parents, he drafted a letter, explained that he was a student, didn't have any money, and enclosed a check for $500, saying he couldn't afford anything more. They returned his check for $500 and said they'd settle for $3,500. Nothing happened for another 4 years. Joel graduated from high school and moved to Boston to attend university. Then, out of the blue, he received another letter demanding that he appear in court. You see, he was one of 30,000 people who'd received the same kind of letter. They were being sued by companies like Sony Music, Warner Brothers, Arista Records, all coordinated by the Recording Industry Association of America. Joel offered to settle the suit this time for $5,000, but the record companies now wanted $10,500. At this point, Joel was contacted by Professor Charles Neeson. He's a law professor at Harvard University and is a founder and co-director of the Berkman Center for Internet and Society. He offered to represent Joel in court along with his students. Professor Neeson believes that the internet is a kind of digital version of the commons. These were common grazing lands in, for example, England in the 17th century that were enclosed so that rich landowners could graze their sheep and cattle on the land exclusively, not allowing for regular villagers to graze their one cow or just a few sheep. Neeson believes that the internet was started as a public domain. Recently, it's been fenced off by capital investors who want to increase their profits through exclusive property rights. Joel lost his case in court, as he and the professor expected. He was found guilty of having downloaded 30 songs, and he was fined $22,500 per song. That's a total of $675,000. Well, he's going to appeal, because if he doesn't appeal, his only other choice is to go bankrupt. Sociologists will tell you that markets are embedded in society through law, politics, and morality. The market for property rights in digital music is embedded in American law through the Digital Theft Deterrence Act. However, it's not embedded in morality. Not only are there academics and institutes that think digital file sharing is not theft, there are artists too. John Perry Barlow is a lyricist for the group The Grateful Dead. He thinks that digital file sharing is a new version of the old gift economy. When new markets are created, morality is often contested. And it's not the marketers who always win. When public libraries were first created, publishers of books complained that this would ruin the market for books. When paperbacks were first invented in about the 1930s, you could find inside the front cover a notice that this book may not be lent or resold. You don't see that anymore. Markets require legitimacy, political, legal, and moral legitimacy. When Mahatma Gandhi ordered his followers to march to the sea so they could make their own salt from the seawater, he was breaking British law, which had a monopoly over salt production. Was he morally right? Well, according to the Indian people, even more so. This has been the Moral Economy column for August 2009. This column is published in newspapers, by email, and over the internet through YouTube. If you'd like to receive an email copy of this column, send me a message at office@christopherlind.ca. Thanks.